Merry Christmas. I hope this finds you and your families after a wonderful holiday. I'm Tim's sister, Katie, and I have a couple of things that I'd like to share with you today about Tim's case. First, I'm going to be talking about the constitutional issue that we are going to go to the federal appellate court with and explain a little bit more about exactly what the trial court did that hopefully the appellate court in federal is going to correct. Second, I'm going to talk about the investigation into the ethics of one of Tim's appellate attorneys and some of the questionable things that he did while he was working for Tim. And then finally, I have a couple of updates about the federal calendar and what his supporters can expect in 2019. So, first off, I'm going to talk a little bit about there's been a couple of questions about what exactly we are going to talk to the federal court about, what Kathleen Zellner is going to argue once we are there. And there's a lot of issues. The federal court is designed to make sure that all of the state actors have acted constitutionally. And in Tim's case, it is really clear that they didn't. The main, most egregious thing that happened was that the trial court did not keep a honest record of what happened in Tim's trial, and they are not letting us correct the record, which is our right to do. Where this comes in, especially, is in the case of the jurors watching videos after the trial had concluded that changed their verdict from a hung jury to a guilty verdict that we are still trying to overturn and get a new trial. What happened with Tim, it's a violation of due process in the Sixth Amendment in particular. The Sixth Amendment is the one that guarantees everybody not only a right to an attorney, but most importantly in Tim's case, a right to a public trial and to confront both his accusers and all evidence against him. During the trial, there are ample opportunities for both the state and the defense to put up any evidence and in the form of witness testimony or exhibits, any information that they want to induce belief in the jury in order to either convict or acquit a defendant. And so what happened during Tim's trial is that when the state was interviewing the state forensic interviewer that talked to the accusers, they mentioned the forensic interviewer mentioned videos that were taken of the accusers talking to them. And the state introduced DVDs, just like this one, that were introduced as exhibits to her testimony, to the interviewer's testimony. What is important about this is that at no time did they play these. So while the plastic here, the DVD and the jewel case, are considered evidence in the case, the contents of them are not, because they were not presented in the courtroom. Had they wanted to play them in the courtroom, there would have been a lot of things that needed to happen for them to be able to do that. Number one, they would have had to give us, the defendants, a copy of them. And they told us that we were not allowed to have a copy of them because they were not going to play them in trial, which is actually true because they did not play them in trial. Had they played them in trial, we would have had to have a pretrial hearing where we would have contested the contents that the jury was going to see in terms of editing, what they were going to be able to see, and exactly the DVD contents of what the jury would see. Since that didn't happen, the state could not introduce that. But the state did tell the jury in their closing argument, remember, there were those DVDs and there must have been something on there that was good, but they did not show them. So what happened in Tim's trial is, for the most part, what happens in every trial. When you see a Hollywood movie about a trial, after all of the evidence is presented in the jury or in the courtroom, the jury hears the closing arguments, gets instructions from the judge to go back to the jury room and reach a verdict. What happened in Tim's case is that the jurors decided at some point in the deliberations that they wanted to see what was on those DVDs that were entered as exhibits. And what should have happened at this point is that they should have submitted a written request to the judge through the bailiff that said, Judge, we would like DVD viewing equipment, a TV and a DVD player, in order to watch these. And what should have happened at that point is that request should have been recorded. The parties, both the state and the defense and all attorneys, should have been called back into the courtroom along with the court reporter and the jury, and they would throw back and forth arguments as to why or why not the jury should see those. Um, since the jury was not shown the contents during the trial, we would have won that. We would have said, Judge, there was no pretrial hearing for these. We don't know what's on the DVD since the state wouldn't give us a copy. But instead, in Tim's trial, the bailiff did not require the jurors to write a request to the judge. The bailiff simply rolled in a cart, did not tell us about it, did not record it into the official record of the case, and the jurors watched these two videos that were edited to the state's satisfaction, but we were not allowed to see. And the jurors later on said in interviews with a private investigator that they changed from hung jury to a convicting jury based upon those videos that were not shown in court. When we went to an appellate court for this particular issue, the appellate court looked at the official record of the case and said, well, they don't seem to have watched the videos in court. There's no recording of any request to get DVD equipment, viewing equipment, so therefore it didn't happen. We know based on the juror foreman affidavit that they did request it. They did get that request granted. But all appeals to this point have cited that lack of record of them viewing it as reason to deny Tim a new trial. We attempted to correct this during one of our appeals, that there is a rule in Tennessee Rules of Evidence number 606B, which states two parts. Part one, a juror in general may not testify as to why they reached a verdict. They may, however, part two, testify as to any extraneous information that they received or any influence that they received in the jury room that was not included in trial that did influence their verdict. So when we got to that appeal, we were being represented by attorney James O. Martin, J. Martin. And he argued that the juror should be able to testify based on the extraneous evidence having viewed it, and said at that point, we are not going to ask the juror how they came to their verdict, just to correct the record that the trial court should have had right in the first place, that the jury did watch these videos that were not entered as evidence during the actual trial. The judge denied the request right there and then. This is the same trial judge that's in charge of the bailiff, and said to our attorney, Jay, you can appeal this, but I'm not going to let the juror up here because I'm going to read 606B as just the part where it says a juror may never testify. So the appellate board at that point denied us based on the fact that Jay didn't appeal that, which brings us to the ethics investigation into James Martin that the Tennessee Board of Professional Responsibility has opened. The Tennessee Board of Professional Responsibility, they have a great website at www.tbpr.org. They are an independent of legal action in the courts. So usually if you had a problem with your attorney during like a trial, you can cite ineffective assistance of counsel. This is not that. This is, in terms of the ethics, a problem of how he handled our case. Most of the complaints that come to the BPR are about like public defenders that their clients can't get a hold of them, and they're calling and calling before trial, and finally the BPR tells their attorneys, like, you got to call your client. So that's the bulk of what the BPR handles. But there is a small sliver where this is the only recourse we have to say, hey, our lawyer had a conflict of interest, and that's exactly what happened here. The mission statement is on the BPR page, but in general, what they do is regulate and supervise the practice of law and ethical misconduct, attorney discipline, and any investigations into these. The results of this can be anywhere from a private informal admonition to public censure, to even if there is criminal conduct on the basis of a complaint, it can refer a case to the Tennessee Bureau of Investigation, the TBI, and there can be criminal charges that go to the Tennessee Supreme Court. So there's a lot that can happen. What we're basically looking for is to have the BPR agree with us that there was a conflict of interest. And the conflict of interest that we have with Jay is two parts in particular. Number one, there was a major problem after that hearing where Jay tried to get the juror up on the stand, and the judge says, well, you can appeal that if you want. What Jay did at that point was write a brief to the next appellate board based on that decision. And we asked several times during the course of about 6 months, Jay, we need to see this brief, and we need to make sure that is in that brief. And he kind of went missing for a while. And we had emails upon emails of, Jay, we need to discuss this. Jay, we need to have the brief. It's due in January, and so on and so forth. And we just weren't hearing from him. So a couple weeks before the brief was due, he sent us a copy of it. And that issue of not having the juror being able to testify was not in that brief. And so we had Tim does all of his emails to lawyers through me. And so there is a email where I specifically say, as Tim, that we need to have that issue in the brief because that is the crux of our appeal. And he wrote back and said, oh, yeah, I'll put it in there. That'll be in the final brief. But we're having a real hard time hearing from him. He told us at that point that he was going to be changing his job. He got a new job offer. And so he was going to help us transfer to a new appellate attorney, which he did. But lo and behold, that brief went in, and he sent us a final copy that the court received. And that issue was still not in there. So in general, when you tell your lawyer to do something for you, if it's not illegal, they have to do it. So we have ample proof of us telling Jay we want that appeal in there, that issue of not the juror reading Rule 6060B, half of it. We want that in there. And he agreed with us verbally and in writing, but then he just didn't do it. So when we got the appeal back, they denied us based on the fact that we didn't have that issue in there. We found out months later that the entity that offered Jay this position was the Nashville District Attorney. So it was our opponent in all of this appeal. And we got a response back from Jay that he and the DA were very good friends, and the DA offered him a position, and there's nothing to see here. You guys are just kind of dreaming up things that went wrong. However, according to the Board of Professional Responsibility, Jay was supposed to let Tim know in writing that he had a job offer from the DA, who was his opponent as he was representing Tim, and that was the reason why he needed to he wanted to transfer Tim to a new lawyer. He didn't tell us any of that, and he didn't tell us that he changed that particular issue in our appeal either. So he really hid a lot of things from us, and the Board of Professional Responsibility is currently looking into that situation. So just to give you an idea of what we're talking about here, our end of the complaint here, this is a 27-page complaint to the Board of Professional Responsibility about this whole situation. And Tim has really gone to great lengths to make sure that we have all our bases covered. This is our appendix. This is all of the emails that prove that this conflict of interest happened, that we didn't hear about it from Jay as the Board of Professional Responsibility told him to do it. And his answer is 2 pages long. So he has absolutely no proof that he did what he was supposed to do. And he's basically saying that Tim didn't have a case, which is bull, because that Rule 6060B is still in effect. A juror can testify that they were exposed to extraneous information that that didn't even alter their verdict, just that they were exposed to that. And in Tim's case, that they did not do a written request as is supposed to happen according to the Sixth Amendment. So what we're hoping for with this It's just an acknowledgement from the Board of Professional Responsibility that there was a conflict of interest, that we did tell Jay to appeal that specific issue, so that when we go to federal court and they say, well, you should have appealed that we can say, well, this guy that said he was working for us was apparently really good friends with the DA and just didn't do what we asked him to do, didn't do what any lawyer should have known and should have done. So that is where we are with the Board of Professional Responsibility. We are currently on the federal calendar for a couple of updates with the case. Kathleen Zellner and her associate Nick Curran wrote an initial habeas corpus brief back in 2017 that we are going to update with a supplement that is due January 28th. Another just kind of housekeeping thing with the federal appeal is that we have been transferred from the Western District of Tennessee to the Central District of Tennessee, which hopefully won't slow us down any, but we are just being really vigilant because Tennessee has thrown up so many roadblocks in our way that have been so illegal. So even though right now we don't have any reason to suspect that there is anything hinky about that transfer, but we are keeping our eyes open, and Kathleen Zellner and Nick Curran are for sure keeping their eyes open to make sure that that they don't pull anything else on us. So what Tim's supporters can expect in the new year is basically to be on call to help. We don't exactly know what that means. That could be anything from asking you to call certain people in the government to let them know that we're watching, to perhaps a physical demonstration in Central Tennessee at some point if things need to happen and we need to show our strength in numbers. 2018 has been a fantastic year in terms of gathering support for Tim. We have added over 200 people to our supporter website on Facebook. So thank you to everybody who has shared his story, who has asked your friends to read it. We've had a lot of law students that have been really interested in what's going on here, because it is just so egregious that they have the state of Tennessee has bent every law that they can possibly think of in every way to keep this bad conviction on the books. So we really will continue to need your support and your voices to make sure that Tennessee understands that we're not going away. This is an injustice that we are going to fight until Tim has a new trial. And that's going to be fun because we just have so much evidence that we didn't have the first time around, of the police fabricating evidence, of the state fabricating evidence. And if there's another trial, Tim will be acquitted. That's my personal viewpoint, but I think most lawyers who actually take a good deep look at what happened here would agree with me. So thank you again for all of your support. Please continue to share Tim's story and to support Tim. I do make sure that he hears all of the comments that you leave on his page. So if you do have any messages for him, please just put it on there and I'll make sure that he gets them. Other than that, I look forward to the next time I talk with you. There are a couple of questions that have been brought up that I'll hopefully be making more videos to explain. And if there's anything else, just let me know. Thanks so much. Good night.